can be a partial response to this problem. Okay, I'm up to my fourth question. The fourth question is whether there are any common principles that apply across knowledge institutions. And I'm going to suggest 4. First, just a second. First, knowledge institutions aspire to impartiality and objectivity in working towards the truth, in working towards better understandings. Second, knowledge institutions have a commitment to apply relevant disciplinary or, in the case of the press, professional journalistic standards with appropriate independence. Third, knowledge institutions should have an attitude of what I would call epistemic humility, of openness to one's beliefs being disverified. Or, as Professor Tarun Kaitan recently put it, should have an abiding attitude of revisability in light of new evidence. And fourth, knowledge institutions should display a commitment to having a plurality of sources so that not all knowledge institutions are controlled by the same power holders. These 4 principles, I suggest, should inform actions by knowledge institutions and by legislators, jurists, scholars, citizens in assuring their healthy sustenance. All right, I'm up to my 5th and final question, and I think I have about 15 or 20 minutes left. And that final question is to think about the implications of this analysis, of this new framework I am suggesting for constitutional actors. And given the occasion, I'm going to focus on courts, on the role of courts. Now, sometimes courts have to perform counter-majoritarian functions. For example, protecting the rights of persons charged with terrible crimes, their rights to be informed of the charges against them, to be able to have consult with their own lawyer, and to mount their own defense. These rights are rarely popular in the moment, but they are vital to a decent constitutional system. Courts play a legitimate counter-majoritarian role in enforcing such rights, and also in preventing majoritarian biases of race, ethnicity, or religion from denying equal treatment and respect to minorities. But sometimes, as Brazilian Supreme Court Justice Roberto Barroso has argued, sometimes constitutional courts play a more majoritarian role in making the law more representative. Now, I would expand on Justice Barroso's discussion of this category to include John Hart Ely's idea that courts' intervention is particularly justified when courts act to support and clear the channels and processes of representative democracy itself. When courts protect knowledge institutions and knowledge producers, that is what they are doing. Information forcing decisions and decisions protecting knowledge institutions serve this goal of protecting the knowledge base, the very epistemic infrastructure that is necessary for constitutional democracies to work. Now, as I indicated earlier, courts themselves are knowledge producers in their own work as fact finders and law articulators. Courts can serve as what I call an impartiality resource for fact-finding in a time when faith in facts and institutions has declined. So courts should always consider how to improve their own procedures for their own fact-finding, as well as for checking fact-finding in other branches of government. Professor Kenji Yoshino has written about the importance of a trial, fact trial, held in the U.S. on whether same-sex marriages impose social harms or harms on children. The trial court judge was appointed by a Republican president, George H.W. Bush. And I mention this because that party has been very conservative on LGBTQ issues. The judge held a trial over many days. He heard witnesses from both sides testify and be questioned by opposing counsel. The trial court's findings of fact, based on this proceeding, were highly persuasive that the empirical arguments offered to support a ban on same-sex marriage were without foundation. The facts were not there to support it. And this is an example of a court acting as a knowledge institution itself, contributing to democracy's epistemic infrastructure. But in addition to serving as knowledge institutions directly, courts also have responsibilities, I think, to develop the law of constitutional rights and of public administration with sensitivity to the special role of knowledge institutions. That is, I think, courts play a very important indirect role in supporting and protecting our knowledge institutions. Let me discuss a few areas. On the press, issues may come before the courts involving taxes or licenses or building permissions or prosecutions or civil actions against reporters, editors, or publishers for alleged violations of law that may concern national security or may involve defamation. In these proceedings, courts must bear in mind the highly important knowledge functions that press institutions serve in democracies. Courts should thus be wary of approving government efforts to deny or terminate licenses, or to impose unusual taxes on press organs, or to imprison, fine, or persecute reporters, editors, and publishers, especially of organs critical of the government. It is the role of the press to be critical of the government, to draw attention to its possible shortcomings. Without a vibrant press, democracy withers. Courts' role is to be an independent body between governments and the press in order to enhance the representative character of democracy by assuring the free flow of information about the government. Press needs access to information and to be able to protect its confidential sources within reason. Courts play a key role in securing these means for the press to carry out its informational role. But in my own country, the Supreme Court has been unresponsive to the needs of the press for access to information and for confidentiality for their sources. The U.S. court has also been skeptical of favorable treatment of the press in statutes, for example, exempting news corporations from certain election expenditure limits that apply to other corporations. The U.S. court, I think, has been motivated by a concern that the press cannot be defined without discriminating based on the political content of the press. But I and other scholars have argued that the press can indeed be defined neutrally through resort to a range of criteria. Courts have responsibilities then to protect the press from unwarranted efforts to hobble it, and also to avoid obstructing reasonable legislative means of advancing the news reporting function of the press. Now let me turn to universities and academics, because as I mentioned before, we have seen rising attacks on universities, both institutionally, as with the forced move of the Central European University out of Hungary, or against individual scholars whose professional expertise leads them to critique their government, as occurred with Professor Sidursky in Poland, who faced duplicative civil and criminal challenges, consuming much of his time, resources, and attention for having been critical of the Polish government's constitutional moves. Again, it is the role of courts to provide an independent break or check on such efforts, viewing government efforts to suppress scholars with great caution. Now, in disputes between professors and their own universities, the court's role may depend on the degree to which the university is operating as an autonomous faculty-governed body applying their own disciplinary criteria. And I'm happy to elaborate this point further during Q&A. In both areas involving the press and scholars, it is important to remember that the speed of proceedings matters. The harassing potential of litigation, however it's resolved, cannot be overlooked. So courts should also play a role in assuring speedy resolution of such disputes to avoid chilling free scholarly inquiry and the work of a free press. As mentioned before, some U.S. states have enacted laws prohibiting the teaching of critical race theory or of the idea that the U.S. is a racist system at the university level. In my own opinion, I think it's pretty clear that those laws are unconstitutional at the university level under current doctrine, but the laws are so new there have not yet been authoritative judicial decisions. But in the meantime, some university professors are leaving their universities in states that have such laws, and others may be intimidated from teaching what they believe to be true. Courts need to, when asked, step in and declare such laws unconstitutional and do so in short order. So constitutional doctrine and resources should help secure the relative autonomy of institutions of higher learning and academic freedoms for faculty to research and teach in accord with their disciplinary norms. All right, with regard to government